We're going to talk today in our brown bag. It's going to be a brief half-hour discussion about your rights during pregnancy. And for further review, or if you wanted to look further into this policy, we are going to be looking at policy 3-100, and that's what we are taking this presentation from, as well as some of the guidelines that the EEOC has given us. So if you have any questions during our time together today, go ahead and put those in the chat and we'll either address them as they come or we can wait until the end when we have a question and answer session. So we will go ahead and get started. I thought it would be interesting to look at a couple of the cases that the EEOC has recently brought lawsuits against big companies in relation to discrimination of people who are pregnant. And their first one we're going to review is the Ford Corporation. So again, these are just recent suits that have been brought against these companies that we're going to look at. So according to the EEOC's lawsuit, Ford violated federal law when it refused to hire a pregnant applicant to work at a stamping plant in Chicago. Due to her pregnancy. Now, she had already applied and was given a conditional offer, and that was going to be subject to passing a physical drug test and a background check. So she went in for the physical and disclosed that she was pregnant. After the doctor had cleared her to go to work, Ford did not schedule her to start work. So she repeatedly called Ford to say, when do I get to start? And they kept putting her off and eventually told her they would no longer needing her to work for them. So she filed the suit with the EEOC, which I found to be really interesting. So she was awarded $118,000 for that. The next case was against Circle K. So the EEOC had determined that it had reasonable cause to believe the Circle K denied reasonable accommodations to pregnant employees and those with disabilities, subjecting them to actions such as involuntary unpaid leave, retaliation, requiring employees be 100% healed to return to work, or terminations. And Circle K was sued, and they will now pay $8 million to resolve this matter. And that includes a class fund to compensate for these impacted employees. And that was all the way back from July 10th of 2009 to September 26th of 2022. So that was quite a few people. Why do we bring these up? Well, it's just important to note that pregnancy discrimination is still a thing. I know sometimes women, when they apply for a job, if they're pregnant, might think that they might be discriminated against because they are pregnant. So we're going to go a little bit into some frequently asked questions about your rights as someone who may be pregnant or may become pregnant. So discrimination of women who are pregnant often arises from stereotypes and assumptions about their job capabilities and commitment to the job. For example, an employer might refuse to hire a pregnant woman based on an assumption that she will have attendance problems or maybe leave her job after her child is born. Just on a personal note, I remember back when I was pregnant with my second child, I applied for a job and I actually hid my pregnancy because I was afraid that might be something that would, that they might use that against me. So this is something that impacts a lot of people, and it's important to know that we have rights in that area. So employment decisions based on such stereotypes or assumptions violate the Pregnancy Discrimination Act of 1978, which amends Title VII of the Civil Rights Act of 1964. And we're going to go into some of those rights that you have as a pregnant person. So, if my employer knows that I am pregnant or may become pregnant, could I get fired? So under the Pregnancy Discrimination Act, employers they're not allowed to discriminate against you based on the fact that you are pregnant, that you were pregnant, that you could become pregnant or intend to become pregnant, or if you have a medical condition that is related to pregnancy. So in general, this means that you cannot be fired, rejected for a job or promotion, given lesser assignments, or forced to take leave for any of these reasons. It's also important to note that your agency does not have to keep you in a job that you are unable to do or which you would pose a significant safety risk for others in the workplace. However, your leadership cannot remove you from your job or place you on leave because it believes that you would pose a risk to you or your pregnancy. So it's important to note that distinction, that if you pose a threat or risk to the public in your job, then they could remove you from that responsibility. But they can't if they think it's going to pose a risk to you or your pregnancy. The next frequently asked question is, what if I'm being harassed because of pregnancy or a pregnancy-related medical condition? So harassment based on pregnancy or a pregnancy-related medical condition is not allowed under the Pregnancy Discrimination Act or the ADA. So you should report to your supervisor or other leadership, or of course the employee relations team, about any harassment you may have experienced. And that could be whether that was when you applied for a job or during your job tenure. So the next question is, what if I'm having difficulty doing my job because of pregnancy or a medical condition related to my pregnancy? So you may be able to get an accommodation that will allow you to do your regular job safely. This would be like maybe altered break schedule, altered work schedule, permission to sit or stand, ergonomic office furniture, or shift changes. You also may be able to get an accommodation under the ADA. So if you have a pregnancy-related medical condition, such as cervical insufficiency, anemia, sciatica, preeclampsia, gestational diabetes, or depression that meets the definition of ADA standards, you might be able to file a claim with ADA. A condition meets the definition if it would, when left untreated, substantially limit one or more major life activities, so such as lifting, standing, sitting, walking, reaching, those kind of things. And so that might be under that consideration when you're applying for the ADA accommodation during pregnancy. You don't need to have a particular accommodation in mind before you ask for one. Just be aware that in ADA accommodations, that if it poses a significant burden on the employer, it may be denied, and that the employer may suggest a few things, and they can choose which one to give you under those accommodations. So just be aware that you want to talk to your supervisor if you want to look into an accommodation. And again, the employee relations team is always here to help. Next question. What if there's no way that I can do my regular job even with an accommodation? So first, if you're being told by your healthcare provider that you can't do your job safely, and for example, you need light duty or can't do your job because of a limitation or restriction, you may want to make sure that's really true. Maybe the medical provider isn't aware of some accommodations that can help you perform your job safely. So just make sure that you look into that and speak with the ADA coordinator or employee relations, the employee relations manager, which is Passion. If you can't really do your job safely with an accommodation, then you might be able to get some altered job duties under the Pregnancy Discrimination Act. Next question, what if I can't work at all because of my pregnancy? So if you can't work at all and you have no paid leave, you may still be entitled to unpaid leave as an accommodation, and that's where you may qualify for leave under the Family and Medical Leave Act, or FMLA. So that's another consideration during your pregnancy. The next question is, what should I do if I need an accommodation, light duty, or leave because of my pregnancy? So the first conversation is start by talking to your supervisor, or the next level up, your division director, or HR, and make sure that you are clear about your rights and what accommodations can be made. So you can't, just be aware that you can't be terminated or be refused hiring or promotion because you asked for an accommodation, or because you need one, or you can't be charged for the cost of that accommodation. Now, this doesn't mean that we can excuse poor job performance, even if it was caused by a pregnancy-related medical condition. So for this reason, it may be better to ask for an accommodation before any problems occur or become worse. So again, that communication with your supervisor is really important during this time. Are there any questions so far?
There's none in the chat.
Okay, terrific. All right, next question. What should I do if I think that my rights have been violated? So you can contact that member of your leadership or the employee relations team, which is Passion and Tracy and myself. Now let's talk about parental leave. To qualify for parental leave at Salt Lake County, you must be a benefits eligible employee and you must meet all the following conditions at the time of the birth or adoption. So this does cover adoption. The employee must have worked for Salt Lake County for 12 months or 52 weeks with no break in employment. The employee must have worked at least 1,250 hours during the 12-month period immediately prior to the requested leave date. And the employee must be taking leave for the birth of a child and to care for that child or the placement of a child for adoption and need to care for the newly placed child. So that is a terrific benefit that Salt Lake County gives. So that could be the mother or the father can take parental leave. Now, if you are the parent giving birth, you're entitled to an additional 6 weeks. So parent, mother, father are entitled to that 6 weeks of consecutive paid leave. And if you were the birth mother, then you are the birth parent, you're able to take an additional 6 weeks of consecutive paid leave. So if you were giving birth to a child, you would have up to 12 weeks of paid consecutive leave. Other questions on that? That can be a little bit confusing. All right. Now, what about when you return to work after giving birth? HR Policy 2-600, that's found in Section C and it's number 7. For up to 1 year after birth of a child, an employee who is breastfeeding will be allowed to take a reasonable unpaid break, so it's unpaid break, each time the employee needs to breastfeed or express breast milk. The agency will provide a place for the employee to use other than the bathroom, which is shielded from view, free from intrusion, and functional for expressing breast milk. Now, I know Sadie's on this call, and I spoke with Sadie about Healthy Lifestyles is putting together a list of breastfeeding sites in each work location, so you can contact them for details. Sadie, do you want to add anything to that, where you guys are at on that list?
Yes. Oh, thank you for bringing this up. Yeah, we're collecting a list of all the places, and so it would be really easy for your employees to go to our website and see where at their location they can go to express milk or breastfeed. But we need help of other places. We've heard back from maybe a third of our county buildings, so if we can get any help that we can, if anyone's interested in helping us along in this journey of getting all the locations, that would be extremely helpful.
Okay, thanks Sadie so much, appreciate that. Any questions about that? All right. Now, recently the policy has been changed. It's policy 4-200.D, and that is changing the bereavement leave policy to include miscarriage and stillbirth bereavement. Hopefully this is never something you have to take, but just being aware that it is something that is new to Salt Lake County. So the policy states that any employee may take up to 3 work days, and when they say any employee, that means it doesn't have to be a benefited employee, can take up to 3 work days of paid bereavement leave in the following circumstances. So following the end of the employee's pregnancy by way of miscarriage or stillbirth, following the end of another individual's pregnancy by way of miscarriage or stillbirth, if the employee is the biological parent, or you can provide documentation that you were to adopt a child that was stillborn or miscarried, or you had an agreement with a gestational agreement with someone in accordance with Utah code that the employee would have been the parent or the child as a result of this pregnancy. So it does cover several areas of miscarriage, but how does this go with the funeral leave? It's not separate from funeral leave. It would be considered concurrently. It would still run concurrently with that. So are there any questions on that new policy we can clarify? Okay. All right. Are there any questions that you have for any of us? We have Passion on the phone. We also have Tracy here. Anything that we can clarify about this policy of pregnancy discrimination and the different, I know that sometimes there's different nuances to maybe your needs. So the best thing to do would be to either contact your supervisor or the employee relations team. Here's our information, Passion, Tracy, and myself's information if you wanted to reach out for further questions. Sometimes this is going to be a sensitive topic, and you may want your privacy, so we're more than happy to speak with you one-on-one.
So, Michaeline, we do have a question from Carla who
Sure.
asked, and I believe this is in reference to bereavement leave.
Okay.
Can you get the time if the miscarriage is in the first trimester?
I believe it's any time during the pregnancy. And Passion, maybe you could clarify that, but it doesn't specifically state what trimester it has to be in.
Yeah, that would be my comment. As Carla, policy is silent on the time frame. It does say biological parent if the child is born, as a result of pregnancy, gestational agreement. I mean, there's a lot of words in there, but I would believe that if the miscarriage occurred in the first trimester, it would still be covered.
And I would assume that gestational agreement means like a surrogacy. So and again, those, if there was an adoption to occur with a stillborn or a miscarriage or a surrogacy, then you would need legal documentation that you were the intended parent in order to be able to have the 3 days paid bereavement. Great question. Anybody else have a question? All right. Passion, did you want to add anything to our presentation?
No, other than great job. I know that this is somewhat of a difficult topic, but we don't speak about it a lot. So I'm so happy that we were able to have this information for a small audience, but we do have the recording, so please share with anyone. And we hopefully will invite you guys back or see you guys on our next Brown Bag.
All right, thanks everyone.
Thanks,
Again, reach out to us if you have any questions.